A very good evening. We are hosting an exclusive panel discussion with the YIF alumni who will be leading a discussion on the topic, is judicial activism a legitimate means to social change? In addition, speakers will also share their individual journeys as legal professionals and how the fellowship played an essential role to help them pave their way professionally and intellectually. The Young India Fellowship grooms socially conscious leaders and change makers for the 21st century. It is offered as Ashoka University's flagship residential year-long postgraduate diploma in liberal studies, comprising of elements such as academic learning, live action projects, mentorship, and critical writing. We'd like to now introduce the panelists and the moderator for the day. Divyanshu Rai from the class of YF 2016 is a disputes resolution lawyer practicing before the Supreme Court, High Court of Delhi, and other tribunals in Delhi. His primary area of practice is constitutional law, commercial disputes, and insolvency laws. He graduated from the National Law Institute, University, Bhopal. The second panelist for the day, Vasundhara Kanoria, from the class of YF 20, has interned with the United Nations and other human rights organizations. She's currently pursuing her master's in psychology and economics from Ashoka University. She graduated from the Institute of Law, Nirma University. The third panelist for the day, Shraddha Upadhyay from the class of 2019, has worked on urban governance and child rights at IIM Ahmedabad. She currently works with Seva Ahmedabad on issues of early childhood care. She is a researcher and writer who graduated from the Rajiv Gandhi National University of Law, Punjab. And finally, the moderator for the day, Anchal Jain, who's a graduate from NLU Lucknow, is an advocate and a current Young India Fellow. Over to Anchal to contextualize the panel and take the conversation ahead.
Thank you, Shambri. So first of all, I'd like to give a virtual round of applause to all our panelists here. And I would also like to thank them for taking out time from their busy schedule for being a part of this session today. So how we're going to format this session today is that we'll have 30 to 40 minutes of the panel discussion, and it will be followed by 15 to 20 minutes of Q&A. So please feel free to write your questions for the panelists in the chat. In the last few years, we have witnessed many activist movements, not just in India, but all over the world. It has undertaken many forms and has been dramatically visible in almost every sector of our lives. But what is being seen right now is a dramatic shift in the very notion of what constitutes activism. Even though we have very different organs of the government that have their own well-defined powers, we see an overlap of these functions very often. For instance, the Supreme Court suo motu cognizance of the lapses in the government's handling of the migrant crisis, or if it was the Arogya Setu becoming an open source, or the CAA NRC protest. These are just examples of activism which are possible only because of the sheer perseverance of the various activists. So keeping in mind the changing narratives of the situation in India today, we decided to hold a panel discussion on the importance of judicial activism. The understanding of judicial activism is largely driven by the people's perception of the role of the courts play. On one hand, you have Upendra Bakshi, who in his article Unfair to Justice stated that even though some decisions may have been based on sentimentalism, overall a good job was done by judiciary. While on the other hand, we have Pratap Bhanu Mehta, who in his book, Rethinking Public Institutions of India, claimed that the judicial decisions are just artifacts of individual judgment, and as a judicial function, courts are required to only interpret law and not make them. So in the current context, is the most legitimate means to advancing social change in society, judicial activism. So let's now dive straight into the discussion. Firstly, I would like to begin by understanding what judicial activism means to you. Keeping in mind the current context and the current events that we are living in and the different layers that judicial activism has, I would like to know your thoughts on what judicial activism means to you and in general what activism means to you. Divyanshu, would you like to go first?
Sure. So instead of just like resorting to maybe a textbook definition of judicial activism as to what is the role of judiciary, what role do they play in a constitutional democracy, if I have to say it in my own words, I would say it's courts trying to recognize the rights framework in the country and trying to give voice to the people who are approaching, who do not have a specific grievance or legal way to approach the court. So in current context, maybe we can say, take example of marital rape, which is the most current controversy, which is pertaining to the role of judiciary. So in a country like India, legislature has many compulsions. For example, all the governments, no one says that we defend marital rape as an exception to the provision of rape, but no legislature, different parties have taken any stand. So that's where courts come into play and decide and declare some provisions of law or identify some rights which flow from the basic framework of constitution and give a judicial legitimacy to those rights. So this is a more what is a layman definition of judicial activism in my mind.
Thanks, Divyanshu. I think that was a very clear and crisp definition of what judicial activism means. Shraddha, would you like to give in your thoughts after this?
No. I think Divyanshu has start with what
Shraddha,
okay,
yeah,
can
sorry,
you
we
hear me?
can't hear you. Yeah, now it's
Okay.
perfect.
So, okay, so I'll start with what activism is. If etymologically we look at it, it would be basically canvassing for a certain kind of a social change. And so many times it happens that a group of citizens uh, uh, can also express their activism in a court of law. So many let's look at the Navteej Singh Johar judgment on the decriminalization of homosexuality in 377. So that could be probably a form of citizens expressing their activism through court. And I also do not want to read the Black's Law Dictionary definition of judicial activism, but I constantly think about what really differentiates judicial activism from any other kind of judicial action. And I think in this jurisprudence, there are two major factors. One is the relaxation of procedure, whether it is the rule of locus standi or on the procedure of evidence as such. And two, this relaxation in the interest of a certain kind of an outcome. Yeah, so I'll stop there.
Thank you, Shraddha. I think those are very good examples to actually define what's judicial activism in the current context. Vasundhara, it would be great if you could also chime in your thoughts as to what judicial activism means to you.
Oh, yeah, thank you. So I agree with whatever has been said till now, and I think it sets the context of what we want to discuss. Just adding in a little bit of more context when we're talking about judicial activism in India, I think it started becoming part of the public vocabulary post-emergency when a lot of judgments started looking at public interest legislations, and the court started taking a more active role in decision-making process, where it was not just applying law per se, but also looking at it from a context of what would be beneficial to the society, hence bringing in this rights framework or this rights perspective. Now, this is where the debate comes in, right? Like, I don't think people argue that judicial activism has not been well-intentioned or the judiciary do not want to actually bring in the rights framework that would be good for the society, but we want to look at whether it's a legitimate way of institution building and would it be good in context of India in the long run, and whether it has been effective in that process so far.
Thank you, Vasundhara. I think you guys have aptly described what judicial activism means. And in a diverse country like India, there are bound to be many activist movements. And since the judiciary is like the fundamental guardian of the rights and the law of the land, I think it's great that it takes up the role of an activist whenever it's needed to sort of ensure transparency and accountability from the government whenever it's needed. So my next question is to you, Shraddha. Considering that you're working currently with the childcare team of Lok Swasthya Seva Trust and have also worked as a research associate on a project between IIM Ahmedabad and UNICEF, do you think that judicial activism has helped in the exploration of the rights of citizens and has probably put certain obligations on the state, like we have seen in the form of right to privacy or health, or say even the right to livelihood?
Thank you for that question, Nachal. Yes, I mean, I do definitely think that judiciary has played an important role in the protection of rights. And I mean, probably that is just really written in the job description of the judiciary in the constitution, right? So But you know, one thing that I often think about is also that in a court of law, uh, when citizens interact with the state, what we often underestimate is the agency of individuals as right-bearing citizens. So one thing that I want to add is that in the exploration of these fundamental rights, as not only judiciary, but various stakeholders have had a very, very important role. And it's important to acknowledge all of those voices. So even in the in the phase before the post-emergency PIL era, there were people from marginalized identities who were approaching the court. And I remember this case we used to read of Hanif Qureshi, where these slaughterers, I mean, where it was against cattle slaughter. I think that case was against cattle slaughter, and it was expressed in a very sophisticated constitutional language. The other thing that I think often comes in is how Supreme Court often defines its this sort of its deliverance of justice in very, very paternalistic terms. So I remember we used to read all of these things about Krishna Iyer and Justice P.N. Bhagwati, where they used to use phrases like little men and all of that. So that often leads to it gives a rationale for relaxation of rules of procedure, which might bring in certain kind of arbitrariness. And I think I've completely gone on the other side. But I mean, it is true that the Supreme Court has played a very important role in also proliferation of all the positive rights under Article 21, and also bringing in directive principles of state policy, and really in shaping the public policy of the country as such. Yes, so I mean, there are just so many things to say there, but I'll stop and I'll come back.
Thank you, Shraddha. I think all this reminds me of all the constitutional law classes that I attended during my college. And I think it's great how under Article 21, the court has sort of gotten under its ambit so many rights that were possible, and has helped keep in mind all the fundamental rights of the citizens. Say, for example, in the form of right to privacy, as under Puttaswamy case, or even the access to internet. So I think that's great. That has helped in the exploration of the rights of citizens. So now that we know that judicial activism has helped in the exploration of the rights, do you think there's some ambit of lawmaking by the judiciary that is defined? Like, for example, in the context of various controversies that are going around, should the courts make law or just interpret them? Given that, Divyanshu, you have been working in litigation for quite some time now, could you give us your thoughts on this topic?
Yeah, thank you for this question. Actually, this will really bring the general debate as to what is the criticism of judicial activism. Because, I mean, if you put it plainly, if something is coming out of something good is coming out of a process, what could be bad with it, right? In terms of, for a layman, you read in the newspaper, Supreme Court identifies this right, this person gets these rights. So what is wrong in it? So that's where the general concept of separation of powers come into picture as to what's the role of the parliament, what's the role of the Supreme Court, and what is the role of other constitutional courts and executive. So again, it's a very cliched thing. India has separation of powers, from a basic structure. But when you come to practice, how does Supreme Court come into picture, or how High Court come into picture in this controversy? There are 2-3 ways. One way is that a PIL, most common thing, gets filed, or a citizen of India approaches the court that his fundamental right has been violated by a certain executive action or a certain legislative action. Thirdly, that they challenge a particular provision or particular policy before the court. So in all these different spheres, the role of constitutional court comes into picture. And when I talk about courts, it's not the Supreme Court, because in our country, actually, High Court has even wider powers than Supreme Court, if technically we talk about our constitution. Although in the way we read media, it only thinks that Supreme Court is the only court in the country who is doing all this. So even High Courts are equally powerful. So when it comes to a person of challenging something that it violates constitution, court is completely within its jurisdiction to decide those issues. That every law, policy, every action of state in our country has to be within the framework of constitution. The second is when they try to say that a certain right has been violated by a certain action of the courts, or certain rights are being violated by inaction. So a prisoner is being tortured custodially, or someone's business is expropriated. So all these are clearly, again, there is not much criticism. No legal scholar is going to say that court deciding an action as bad is problematic. Where it actually becomes more difficult is PILs and or courts taking suo motu actions in certain cases. So that's where the legal position as we speak is that it's Parliament's job to lay down the law, executive's job to implement the law, court's job is to judicially review if those actions are permissible within the constitutional framework or not. But that's where the expansion starts. How did it start in our country? There were lots of citizens not being approached, afford a lawyer, government accesses. So someone wrote a letter, then they realized that there are so many people, government is complicit in this. So that's where how judicial activism, plainly speaking, started. In this, what are the criticism that Supreme Court or any High Court interferes in the policy matters? So now the question, again, technically the position is court can only interfere where there is something unconstitutional, arbitrary, malafide, or there is a vacuum. So like just to cut it short, there have been examples where court has played an extraordinary task of putting down the guidelines where there existed no law. The biggest example of that is the Vishakha case, where sexual harassment was rampant going on in the country. There was no law to deal with such a specific problem. And for the longest time, I mean, it's only in 2013 that we finally, the Parliament enacted that law. Second thing that I could see is that in many of these cases, legislatures and the executives try to shirk away from their duty. I mean, if there's a piece of law which has been there for 100 years, which is bad, you have taken a position before that, but government doesn't want to do a difficult task of striking it off. That's where courts come into picture. They decide for all these cases of 377, currently marital rape, as I was talking about, then courts have to do their job. So I would say if government fails, court has to step up, but it has to be seen that they do not interfere in the policy making. Which is, again, it's very difficult to say because it will depend on every case, because there are some instances where the policy is so, like the arbitrariness so writ large in a policy that if courts do not step in, the citizen get affected. So it's very difficult to say that whether Supreme Court or a High Court is actually just interpreting the law or trying to do some legal like lawmaking. But if there's a vacuum, the legal position is there's a vacuum, they can certainly do it. Whether if there is a law, can court direct Parliament to enact a law? There are multiple judgments which say that court cannot do that. But if there is vacuum, courts have to step in. And if a Supreme Court or any judge can see that something is very, very problematic and governments are not taking an action, then I don't know. I mean, then judicial activism is our only rescue.
Thank you, Divyanshu. I think you very clearly define the various segments within which the judiciary works and where it expands its powers and where it does not. And I think also, as you mentioned, the process of interpretation by the courts should be towards the improvement of law and not in derogation of the mandate that the courts have been given. And since the scope of judicial review is limited, as you mentioned, so if rigidly followed, I think there can be some strict boundaries of power which are given to each organ of the government. And if it's maintained, I think that helps in the separation of powers that has been given in the Constitution as well. So in continuation of these controversies, what do you think the judges should follow? Should they follow like public morality or constitutional morality? I mean, do you think like the certain decisions appear at times to be more populist in nature, or can you say like less legal, if that's a word that I can use? Sundar, would you like to go first?
Yeah, sure. I mean, see, ideally, the courts should only follow constitutional morality. And I say that because when you talk about public morality, you're in general talking about morality that's defined in a particular space and in a particular time, and it is bound to change after a certain period of time. So for instance, when you look at homosexuality or things like this, which were not considered to be moral in a particular point of view, but now you understand that it's not, like there is nothing problematic or there is no issue with it. So which is why it's important that judgments should be based on constitutional morality and they're not subject to things like mood of the era or mood of what people think. But at the same time, I don't think it would be practical to say that you could completely remove it, because judges are also, in a sense, people and subjects of that particular time. And they're also bound to get influenced by opinions that are prevalent in that time. So, in short, I think my answer would be yes, ideally, I would like to believe that judgments are bound by constitutional morality, but I think it does get affected by popular morality a lot too.
Thank you, Vasundhara. I think those were some fascinating points. Shraddha, would you like to add something to whatever Vasundhara just said?
Yes, I think Vasundhara has answered it well. I would just add a few things. I think there is no question that the court should follow constitutional morality. And at the same time, it is important even when it takes it takes up a public interest litigation. A few basic legal principles, whether it is the procedural rigor or the importance of reason in writing the judgment as such, and the principles of natural justice. I think if these are not compromised, then other sorts of relaxation of procedure are okay in the interest of certain issues, as I think Vasundhara has detailed very well. So thank you.
Thank you, Shraddha. Divyanshu, do you have the same chain of thought, or would you like to add something different to whatever has been mentioned so far?
So, Shraddha actually precisely pointed out the basic tenets that courts should ideally see, because like, just to give you an example from my experience where it can go wrong, legally speaking. So there are many cases which are brought to court's notice. So example, say the firecracker ban, where they decided that we should impose a firecracker ban for environmental concerns. Very good. No one can, again, principally say what's wrong there. But say if you do that without hearing the hundreds or thousands of traders or manufacturers of firecrackers, right, in a notice where they are not a party. So that similarly, or it could be on any trade profession. So affected party has a right to be heard before a judgment is passed against them. That's what Shraddha meant by when the natural justice principle should be violated. And about constitutional morality, as when you were trying to quote Mr. like Dr. Rupen Bakshi, so then what he was saying that by and large, see, constitutional morality, it's not that difficult to pin something down, a popularly moral principle within the four corners of constitutional morality. Because what is constitutional morality? It is what the judge says it is. I mean, in terms of, you have to ground it within the framework of constitution, but by and large, that would be a judge's individual perception about that issue. And that's the one of the major criticism against judicial activism, that it is, as you said, Pratap Baru Mehta also points out, that these are basically a judge decides what constitutional morality is. It's a very, in our jurisprudence in last 4 or 5 years, there were many judgments where this phrase was used, and it essentially means that constitution also has to keep up with the times. It has to evolve. The process of constitutional interpretation has to be transformative. So there are some criticism, the academic criticism of it, that it is not certainly grounded in the legal process, but courts have given it an expansive interpretation, and it does further the aims of societal interests. So I would say it has to be grounded in constitutional morality, but as long as it advances the cause of justice and actual rights of people, it is, I would say that it is a great thing for our societal interests.
Thank you, Divyanshu. I think this discussion just reminds me of my jurisprudence classes where we were discussing ought law and is law. And I think, as you rightly mentioned, that we have to strike a balance between all the interests of the stakeholders that are in the picture to ensure that we're not giving favor to only one particular stakeholder's preferences. So while maybe some orders can be populist in nature, say, for example, certain extrajudicial prohibitions, on the other hand, you have certain decisions which are extremely necessary for ensuring the decent living of standard of the citizens. So my next question is addressed to Vasundhara. Considering you are interested in behavioral science, human rights law, and the intersection of law and policy, do you think that since the court cannot sit in judgment over the wisdom of the policy that has been made, and there can be certain clear cases of, say, judicial overreach, so do you think it can act as a barrier to the separation of powers that has been defined in the Constitution? And if it is so, then what do you think can be the way forward to actually rectify this problem that exists?
So I think this is like a very important question, especially when we talk about judicial activism in India. And I think, I look at it in two parts. So one is the process, and the other is the end result. So talking about the end result, right? Like there are a lot of reasons why the court has stepped in and given a lot of judgments, and we discussed some of them. Like either it could be a vacuum, or it could be some sense of urgency, or it could be something that's really important and the court feels like it has to take up that charge. And we've seen it during COVID relief also. Like court has taken a lot of active role in giving directions even to the state government to take COVID relief measures. So the end result, more or less in India so far, in my opinion, has been good. And I think most people would agree that it has been well intentioned. And even if it might not be, let's say, effective in some cases, or in some cases might not have been necessary, the intention overall had been to create a better rights framework, or to help like more people. But the process is where I think the problem comes in. Uh, Judiciary, in a sense, is not accountable to the people because it's not elected. And hence, when they start taking important public policy decisions, it becomes a problem for the institution itself. And even though we haven't faced a problem till now in India in terms of the end result, or we haven't really felt that the end result is negative in that sense, but I don't think that should discount or take away from the fact that the process is also a problem. Because when we build institutions, we just don't look at the short-term results or how the institutions performed in the let's say like last 20, 30 years. We want to build institutions that last. Therefore, processes in that sense become really important. And in that context, I think judicial overreach could become a very big problem, especially if they continue to take public policy decisions, because A, they're not accountable to people, and B, judgments also to some extent get isolated, like they're protected from criticism to some extent, which again becomes like a really big problem because they are public policy decisions, right? They should have active debate. So I think these are two reasons which I think it could be a problem. But when it comes to solution, I'm not very sure. But I think this is one challenge that we might face when it comes to looking at democratic institutions in India. And this is something that we should talk about, because if there is a vacuum, or if the executive is not performing as we wanted to perform, then there are things that we should do as people, because the solution definitely is not judiciary doing all these things. There has to be a better solution.
Thank you, Vasundhara. I think you very rightly described how whatever is written and how the process is executed are two different things. And I also liked how you mentioned that judgments are sort of not open to criticism and they're slightly protected. Also considering that if you breach into the domain of the other organ, I'm pretty sure that it can be authoritative to some extent as it breaches into the field of the other organ. And if one organ specifically breaches others' territory, I'm pretty sure there can be some disbalances in the power dynamics, as we often see. So great. Keeping in mind the things that we've discussed today, it can be said that judiciary has at times acted like a guardian of the rights of citizens, mostly, to uphold the law. So this was a very fruitful discussion that I had. And I also think my exposure to liberal studies has sort of helped me in structuring the discussion today. So I think now I would just want to move on as to know more about your YF journey. So this segment would just be a glimpse into your memories and the fun experiences that you had at the fellowship, the non-legal segment part. So I remember when I was applying for the fellowship, I had spoken to like 7-8 people to actually know why, as a lawyer, I should join the fellowship. And Vasundhara was actually one amongst those people who I had spoken to. And she had told me that you would have a very different exposure to the different fields that are there out there, and a very different experience altogether. So I just wanted to know why you wanted to maybe explore liberal studies for 1 year, and how do you think liberal arts can fit into a lawyer's life? Divyanshu, would you like to go first, considering that you're from the earliest batches amongst all the panelists here?
So, speaking for myself, I mean, why did I decide to do the YF while being in legal profession? All the non-career reason would be right after college, I was kind of missing the campus life, thinking of maybe studying further. And the only option that I had was probably doing an LLM, which to me was again like zeroing in on further doing law in life, like if and deciding something which I just want to explore other options. And LLM is a lot more academic course. So that's where just the idea of studying YF came to my mind. And that was because of a college senior of mine, Apur, who had done YF earlier and also teaches at Ashoka. So I'd spoken to him, and then I found out that whatever might be the career outcome, keeping aside, this would be 1 year of some extraordinary learning, not in terms of maybe you're going to know a lot, but at least just getting exposed to so many subjects and the entire experience of being taught by mostly professionals or academics, but the courses were not very conventional courses. So that was the idea that I joined YF. While I started doing the YF, there were a lot of, so to speak, change. My worldview changes in terms of you get exposed to so many thoughts, because 5 years of law makes you, all your friends are lawyers. They could be doing certain different things, but just lawyers you interact with. So YF was that way quite an eye opener to interact with other people. You get friends who are from doing different things. You get to know what their views on things are. And that's where I was just thinking when I was trying to like answer this question, that everyone uses the word critical thinking, critical thinking. So critical thinking is part of YF learning experience, but it is not something that is that they teach you in a class. That is something more organic there, because when you go there and you have a certain opinion on a particular topic, and then you meet someone else with a completely different opinion, and then you get to realize, okay, maybe that person also has a point. I mean, that's their lived experience, that's what they have read, that's what they have been exposed to. So that was a great learning experience. And if I can like narrow down to certain topics, uh, like say on entire issue of gender reservations. So, and not to say that after why I have a very clear position on a particular issue, but the entire 1 year of just getting to know different point of views and was a great experience. And that kind of makes you realize that, okay, there could actually be a lot of blind spots that you had because you were just studying with a similar set of people, or just being restricted to one domain. So that was a very different experience for me as far as YF was concerned.
Thank you, Divyanshu. I think I resonate with a lot of points that you've made. Shraddha, would you like to go next and tell us about your experience?
Yes. My experience is also very similar to Divyanshu's experience. So yeah, when I was in like last year of my law, I was just so, I was just really bored of the same script. Like, we were doing just the same things while we were writing papers, or, preparing for moods, or even just understanding law as such. And I did feel that in my, I mean, in the classroom experience in law, there was some sort of academic rigor that was lacking, and which I started thinking about differently when I came to YF also. But yeah, so I just applied, and I was, really interested in many things, and YF made sense because I could not zero in on one thing. So, and when I came to the fellowship, it was exactly better than whatever I had thought of. So I remember one of the things that I was really like insecure with, that I am a lawyer, I should know a law kind of stuff. And I was like very extra conscious of that all the time. And so while the whole liberal arts framework really suited me, I was interested in many things. I was interested in poetry, so I could do courses on that. I was interested in religion, so I could do courses on that. So, but law remains some sort of a main theme of my experience. And one of the things that I find interesting is that while I was doing law, I thought that, oh, we don't know so much. But when I went to the fellowship, I realized that as lawyers, we've read a little bit of everything. So there's a kind of, this consciousness. And so I found it really easy to write papers, etc. in the fellowship, which my other friends who were like engineers really struggled with. And I just also share this. There was this course that we were doing. It was called Art of Communication. And we had to do like a speech. And I spoke on legal metaphors in Ghalib's poetry. So basically you could do whatever. And I really enjoyed that kind of freedom. And most importantly, as Divyanshu also said, that the people that I met there, they are just such a steady set of dependable people whom you can approach for finding jobs, for meditation sessions, poetry, I don't know for what not. And the fact that they are from different disciplines, it just makes it less boring. So yeah, I think that's about it.
Thank you, Shraddha. I think your individual experiences sound great. And I think I can totally agree with what you said, that it's very easy for lawyers to sort of write research papers. And for other people, it's very difficult, considering even 1500 words is a very short limit and there's a lot of scope that. So basically, since people are from such different backgrounds and fields, yeah, so we come across a lot of exposure when we are in YF. Vasundhara, would you like to add about your experience?
I think it was pretty much the same as both of them have already described. So when I first saw, when I first came across YF, I was interested because I saw like the number of courses were really, really interesting. Like they had courses like art appreciation, design thinking, and all of them were like very new and fascinating to me because I hadn't studied it in law school. So that was what it attracted me to YF in the first place. But to be very honest, like even though the courses were great and the professors were great, like my favorite thing about YF was the people, because they're just like really interesting and most of them are like really nice. So even random conversations with people would be a new way of thinking or a new idea that you hadn't probably thought of before. So that experience actually taught me a lot, and I think that was the main thing that I took away from my fellowship.
Thank you, Vasundhara. So my next question is basically to understand how the YF experience was sort of relevant to your professional life. Once you had graduated, say there are a lot of people who probably want to make a career switch, or a lot of them want to go back into law. How do you think as lawyers, the YF experience is going to help us to either go back into law again or to have a career shift if we can? Shraddha, would you like to go first?
Okay. So for me, I think I was not looking for, I wasn't thinking about what happens after YIF for a very long time, even in the YIF, which was, I don't know, I would recommend that. But then, I knew that I wanted to work in research and policy, and that was also something that I was doing while I was doing law. So I was doing a lot of those internships, and the same thing continued in the YIF. And then I was working at IIM after YIF. And I think it really helped me in many ways, because I had never formally read, let's say, the research methods except what we study in law. But the experience of YF, it gives you the sensibility to ask the right questions, to be sensitive enough, when you are in the field. And some of those things, they come very naturally. And let's say you have a problem to solve, or you have an issue at hand, the multidisciplinary approach that helps you like really look at it from all the angles. So I think that was really helpful. And there were courses that I did not study with the same amount of rigor and effort at YF, and there were so many times that I went back to them as I started working. So yeah, it's been very helpful, and helpful in some of these abstract ways, but also in concrete ways, that if I wanted a certain reading, I could always ask any of my YF friends. If I wanted help in I recently switched jobs, right? So the whole so-called the network of YF was just so helpful. So yeah, it's been a great experience.
Thank you, Shraddha. Divyanshu, would you like to tell us how this is going to help a lawyer later on?
Yeah, I can speak for, say, for a dispute resolutions lawyer, or if you want to set up your own practice or even work with a firm. So first, where it helped me really was while YF, the mentorship program, I got two mentors who were senior advocates. One of them became judge. So they were very helpful in terms of asking all my stupid, silly questions about what should I do? I want to do this field of law, that field of law, whatever general anxiety most of the freshers have. Then through that mentorship program only, I got to know about various career opportunities where all I could apply to. So in a way, even my current chamber was kind of related through, I got through like my mentor suggested, then I applied. So that was one of the major things that I, but then if you talk about further in your profession also, you get a wide set of network who are doing a lot of things. So there's someone who's running a startup, someone is working with some company. So even then, if you are a lawyer, and now considering there are not many lawyers, like in terms of every batch, how many lawyers are there? If you're 4, 5, 10 lawyers, then it's like 200 people know only 10 lawyers. So for you to stand out from your batchmates who only have 80 other lawyer friends, you suddenly have a whole set of people who only know you as a lawyer. So I think that's pretty helpful. Apart from the, I wouldn't even call them abstract, apart from the very relevant lessons that you get in various fields, like YIF taught you so much about general India's political economy, history. So all that in some way or the other come to your rescue. Even we had courses on some basic courses on businesses. So all these things, whatever you do, I think is quite helpful both as a lawyer or as any professional per se. I am on mute, I think.
Sorry. Thank you, Divyanshu. I think that was a great point that you made, that in a batch of say 200, if you're only a bunch of like 4, 5 lawyers, so all your friends are only going to know you as lawyers instead of all the lawyers in the law college that are there. Vasundhara, would you like to go next and tell us your thoughts on this topic?
So I was actually more interested in public policy. And I feel like if people who after law want to pursue public policy, YF could be a great way to get started, because firstly, you learn like a lot of random subjects and they sort of help you gain better perspective on issues. Also, a lot of professors are people who are actually working on the field, and they can help you a lot with your own research and your own ideas. And after YF, like that's what I'm currently doing. I'm doing a program called the Masters in Liberal Studies. So after you complete your fellowship, you get an option to extend it for 1 more year, where you can pick specific subjects you want to study and you can do research on that particular topic, and you can then you have to submit a thesis after that. So if there are people who want to look for who are looking for a little bit of a career change, then MLS could be an option if you want to like work in public policy or things like that.
Thank you, Vasundhara. So I'd just like to share one of my experiences here, the intersection between law and liberal studies. So in a critical writing post, we had to write a position paper on can internet memes be considered art? And the intersection between law and liberal studies here was that I tried to look at memes from the perspective of originality and creativity under the Copyright Act and the intellectual property rights. So and looked at it also from a philosophical lens in terms of the art appreciation course that we did. So I think that was a very fulfilling assignment for me because I thoroughly enjoyed my time writing it and it did not feel like a burden at all. And my next question would be to just understand what sort of new skill or maybe a hobby that you had picked up during your time at the fellowship. Vasundhara, would you like to go first now?
I think after art appreciation, I really got into painting a lot. So I think that is one thing that I still do because of YF.
Divyanshu, what about you?
I really enjoyed the art appreciation group. I was a terrible, terrible painter. So, but at least, so I mean, I have not really picked up that hobby, but at least you got to know something about something which you had no idea of. I mean, I still can't draw a straight line, but during the course, you had to make some sketches, make some paintings. So that was a slightly uncomfortable, but a very different kind of experience that you had to go through. If I have to pick out a hobby, say maybe reading different stuff. I mean, not just law or a popular non-fiction, but because when you get interested in a lot of other subjects, you pick up on more readings that you generally were not aware of earlier. So I would say reading other stuff has been one thing that I picked it from YF.
Shraddha, what about you?
Oh God, I also agree with that. I mean, there is so much.
Shraddha, sorry, you aren't audible.
Okay, can you hear me?
Yeah, perfect.
Yeah, I was just saying that I agree with Divyanshu. There is a non-ending reading list. But for me, I think I was connected with the Hindvi club there, which reads Hindi Urdu poetry, and I'm still. It's been almost 3 years since the fellowship, but I still regularly attend their meetings, and I have maintained that connect with the Hindi Urdu poetry and the club. So that has been a very fulfilling experience for me.
For me, I think one of the courses that we're doing right now, cinema and communications, that is a new experience altogether, because we are making a stop motion film or another full short film that we have to make, and we are in charge of graphics, sound, and writing the script and whatnot. So I think that's a great experience. So I think your overall YF journey sound very exciting and memorable. I'm pretty sure that the exposure you gained in various fields and the subjects that you studied helped you in your overall career growth. And I can't believe that my fellowship has just 6 months left. And I'm sure in the future, when I look back at this year, it'll only remind me of the memorable things that I've done and the amazing people that I've met. So thank you all the panelists for your thoughts here. The floor is now open for the Q&A part, and I would just be reading out certain questions that we have, and anybody of you can take up the question and answer that. So Shivani has asked this question: how the death of a judge has affected judicial activism, and what is the level of judicial activism after this incident? And I think it's referring to in the context of Judge Loya. So anybody of you can take up the question to answer it.
Should I go? Yeah. So I don't think, very difficult to draw a specific connection to, I think these are two different incidents altogether. We don't even know what, there is all the Supreme Court judgment dealing with it. But I don't think in terms of, it's very difficult to draw a connection between the two, because generally where we have been discussing about judicial activism, it's more in the sphere of expanding the scope of life. This is a very particular case in a, if it has to, you have to deal with it, it has to be judicial independence. It has to be discussed under the head of judicial independence, but that does not really relate to the concept of judicial activism as such.
Thank you, Divyanshu. That makes sense. So another question that we have is, should the Supreme Court be able to overturn popular opinion? And how often and why should the Supreme Court maybe listen to the will of the people? Anybody of you can take up the question to answer it.
Maybe, okay.
Yeah, Shraddha, you can go ahead first, and then Vasundhara can also answer.
Okay, so by popular opinion or will of the people, if it is codified in the form of a statute, if that is what you mean by overturning, I'm sure the Supreme Court should be able to overturn any kind of popular opinion if it is unconstitutional in nature. And that's why we have the function of judicial review under Article 32 or 226, because there are certain kind of electoral minorities in the country, right? People who might not be the majority in terms of numbers, but their rights should still be protected, and that is the function of judiciary.
Thank you, Shraddha. Vasundhara, you can chime in your thoughts after.
I think pretty much similar to what Shraddha mentioned. And I think this is also similar to when we were discussing about populist morality and constitutional morality. It does become practically a factor, but it should, ideally it should not be. Ideally it should not govern decisions, or it should not be a cause as to why you're overturning a particular decision.
Sure. Thank you so much. So the next question says, do you think courts are taking a lot of time for answering or giving judgments on public interest litigation? I think that's a question. I think Divyanshu, you can answer, since you're in litigation have been in litigation for a long time now.
I don't think it's specific to public interest litigation. On the contrary, public interest litigation, because of the general media attention that they get, still they get resolved in a faster way. But dependency is a huge problem for our courts. In terms of if some interesting solutions could come from the others outside Supreme Court, in terms of all the institutional building, behavioral law work that Vasundhara is doing, probably eventually we will get some solutions to this thing. But it's a huge problem that affects all the cases, not just PILs, but every other case. And the massive reason is it's a problem that because it's due to a lot of vacancy of judges. So whether the government is failing or the court is failing, that's a larger debate into appoint more judges.
Sure. Thank you, Divyanshu. The next question, I think we've already covered. What attracted you to join YIF at Ashoka? So I would move to the next question. Do you think judicial activism plays a key role in keeping a check on the powers of the parliament? Shraddha, would you like to take up the question?
Yeah, sure. I mean, judiciary plays a huge role in keeping a check on the powers of the parliament, not just judicial activism, but I think any sort of judicial review and not an active kind of a, I mean, it is, as I said, the basic role of the judiciary.
Yeah, thank you. So the next question is, what does advice and consent mean to you? Sort of not related to the topic that we were discussing, but if anybody of you would like to take the question.
I didn't really get the context of it in terms of.
I think it's just a very open-ended question. What does advice and consent mean to you? I think in terms of maybe rape laws that discussed that we have.
I mean, into this answer seems a little, a question seems a little different to contextualize, but I could say from my YIF learning experience, I mean, we had a slight workshop on consent generally. So that was, I mean, I could say that where YIF can help you with these concepts is because there's a lot of active discussion on all such topics, which could be considered as something which is out of bounds outside and where not much thought is given to it. So probably a learning like YIF can help people to really explore these nuances of such topics.
Sure. Thank you so much. Yeah, I think we're almost done with the questions at hand. Let me just look at the questions again. Yeah. So thank you all the panelists for taking out time to be a part of this session today. It was great having this discussion with all of you and to actually know about your individual journeys. Even that was a great question. Yeah, sorry. Even that was a great thing to do. Yeah, thank you very much. It was great having this conversation with all of you.
Thank you, Anshul, for having
you.
me. Thank you.
Thank you, Divyanshu and Vasundhara.
Thank you, everyone.
Thank you.